to talk on the topic namely directors. This is one of the critical topic under the Companies Act 2013. Even from the examination perspective, it has got a bigger mark sharing with comparing to other topics. This topic is primarily very important to understand the concept relating to the board meeting, managerial remuneration, managerial as personals. For all those concepts, understanding this concept's understanding is very important. As far as the company law is concerned, the company law protects the interest of the investors. How to protect the interest of the investors? It can be protected only by a certain human agency. If every shareholder starts coming towards the company and they want to manage the company, means it will be ridiculous that company cannot be carried on properly, because all of them cannot own the company together and each one will be doing one thing and the company will be mismanaged. To avoid that, this law brings a concept of certain human agency for the shareholders. You may raise a question, why there is a human agency required? After all, company being an artificial person, it can do anything. Whatever a natural person can do, a company can do. Yeah, of course, a company can do everything as an artificial person. But it cannot pick up a telephone, post a letter, or email, or open the door. Nothing can be done by a company. It requires certain natural persons to do on its behalf. Such persons are called as directors. So what is the duties of these directors? Before understanding the qualification and disqualification of a director, let's understand what is the duty of these directors are all about. The second paragraph covers that. Section 166 of the Companies Act. The director shall act in accordance with the Act and Articles of Association. So directors of the company should act accordance with the Companies Act 2013 and as well as accordance with the Articles of Association of the company. They shall act in good faith in order to promote the objects of the company for the benefits of its members as a whole and in the best interest of the company's employee, shareholder and community, and for the protection of the environment. The director of the company should exercise care, skill, and diligence while exercising the independent judgment of them. A director of a company shall not involve in a situation which may have a direct or indirect interest that conflicts or possibly conflict with the interest of the company. The director should not gain any undue advantage over the company, either by himself or through his relatives or partners or associates. This is a substantive concept which will come in from the perspective of the independent director also. If such director is found guilty or making undue gain, he shall be liable to pay an amount equal to that of the gain of the company. The director shall not assign his office, and assignment so shall be void. I have given a star mark on the word is. If you go to the last point, you will understand that interpretation of the word is. The word is would indicate that the office contemplated was one held by the director at the time of the assignment. So, at the time of the assignment, if that person is occupying the office, he cannot assign it. There's a one popular examination question or a clarification given by the department which is there. Mr. X, a managing director of the company, writes a will by stating that on his death, his grandson Y will become the managing director of the company, subject to the provisions of the Companies Act. whether it is an assignment of the office. No, it shall not be considered as an assignment of the office because section uses the word is. At the time of the assignment, he should be holding the office, then only it shall be called as an assignment. In the given case, will is a testamentary instrument which will be effective only on the death of the person. So, when X is assigning the office to the Y, after the death of the X, it will not be considered as an assignment of an office under section 166. It shall be allowed under the Companies Act 2013. If any of the director contravenes the provision given under this section by virtue of the clause G, they shall be punishable for the fine which may extend to 5 lakh rupees and not less than 1 lakh rupee. The next concept which you are going to see is a director identification number. Friends, probably this is the only qualification a director require under Companies Act is DIN. No other qualification is required. In fact, the Companies Act never says a director should be an educated person, qualified person. All those requirements are not specified under the Companies Act. Whether an articles of association of the company cannot prescribe the qualification. Again, that is questionable. We will discuss about that in some other aspect. When we are discussing about the disqualification, we will discuss about the qualification. So, as of now, I will tell you one thing which you need to understand is the only qualification which has been prescribed under the Companies Act for the director is director identification number. The director should have a DIN in order to become a director. SIN is for the company, DIN is for the director. It's a unique identification number allotted to the director. Here, no person shall be appointed as a director unless he has a director identification number. He must apply for the director identification number from the central government. Within 30 days from the date of the application, the DIN shall be allotted. In practicality, the DIN is allotted immediately, but it shall be considered as a provisional DIN. Within 1 month, it shall be confirmed as a DIN. Because of the technological improvement, there is no issue that the DIN will be taking a month's time for getting it allotted. If any person who has got more than one DIN, he shall be liable for penalty under this act. Hence, a person can have only one DIN. The director should inform that company that he is possessing a DIN within 1 month from the time he is obtained. This is a provision which has been brought prior to this while bringing this act. So 156 no more shall be effective, actually speaking. Because if you read the 152 says that without DIN you cannot be appointed as a director. 156 in contrarily says that every director should inform the DIN to the company once he obtains from the central government. So that provision is no more practically possible. So these are all some of the important provisions of the DIN. Section 158 of the Act says that the director must quote his DIN in every written information under the Companies Act. He should quote it. So a resolution being passed or a minutes being signed, wherever the director is signing upon, it is preferable to give the DIN. That is what section 158 of the Act says. Next, we will move on to section 164, which is a very, very important provision under the Companies Act. Disqualification for the appointment of director. Friends, as I already discussed with you, Companies Act does not contemplate any provision for qualification. However, it has given provision for disqualification. Disqualification for the appointment of the director. When a person shall not be eligible for the appointment of the director. Please understand, this is not a provision for vacating the office. This is the provision for disqualification. Disqualification need to be looked at the time of the appointment, not after the appointment. This is a pre-appointment provision, not a post-appointment provision. So 164 is a pre-appointment provision. Please have a clarity. 164 is a pre-appointment provision and not a post-appointment provision. A person shall not be eligible for appointment as a director of a company if he is of unsound mind and stands so declared by a competent court. If he is an undischarged insolvent, he has applied to be adjudicated as an insolvent and his application is pending. He has been convicted by a court of any offence, whether involving moral turpitude or otherwise, and sentenced in respect thereof to imprisonment for not less than 6 months, and a period of 5 years has not elapsed from the date of the expiry of the sentence. Friends, we'll go by one. First provision, he is of sound mind, unsound mind, stands so declared by a competent court. The unsound mind should be declared by the competent court, then only a person cannot become a director. It is not the mere declaration of the law, or it is not a mere declaration of the doctor is sufficient. The unsound mind should be declared by a competent court. Court should declare that person is unsound mind. Then only he is disqualified under the law. He is an undischarged insolvent, where his liabilities are greater than the assets and it has been confirmed by the court. He should apply to the court and get the order for the same. When he has applied to the court to declare himself as an insolvent, then itself he cannot become a director. So what kind of a provision is this? Why a person is declared insolvent when he is just because he is insolvent, why he cannot become a director? The reason behind he cannot become a director if he is an insolvent is there are so many penalties which has been provided under the Companies Act. If a person is insolvent, he will not be in a position to pay that penalty. Hence, he will stand irresponsible towards the statutory compliance. Hence, he cannot become a director of the company. Let's go to the fourth provision. He has been convicted by a court of any offence, whether involving moral turpitude or otherwise, and sentenced in respect thereof to the imprisonment for not less than 6 months, and a period of 5 years has not elapsed from the date of the expiry of the sentence, and sentenced in respect thereof to imprisonment for not less than 6 months. Suppose a person has been imprisoned on February 2020 until October 2020. So it is greater than 6 months. That person is disqualified to become a director. Until when he is disqualified? For a period of 5 years from the date of the expiry of the sentence. That is 5 years from October 2020, he is disqualified to become a director. So October 2024, he can become a director of the company. Of any company, he can become a director because 5 years has elapsed from the expiry of the sentence. If a person has been convicted for any offense for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. Friends, this is a provision for life term. The D is classified into two things. One is a 5-year term provision and other one is a life term provision. 5-year term prohibition if he has been imprisoned for 6 months or more, less than 7 years. If he has been imprisoned for 7 years or more, then he cannot become a director for the lifetime. An order disqualifying him for the appointment as a director has been passed by the court or a tribunal and the order is in force, then that person cannot become a director of any company. He has not paid any calls in respect of the shares of the company held by him, whether alone or jointly with others, and 6 months have elapsed from the last date fixed for the payment of the call. Suppose on April 2020, a call has been made. The due date for the payment is 1st of May. As on 1st of May, the director has not paid the call money, whether the share is being held by him individually or jointly. From 1st May, 6 months has elapsed. He has not paid the call money still. In that case, the director cannot become, a person cannot become a director of any company after the expiry of the 6 months. Friends, again, this is a life term provision. It doesn't have any specific time period. It is again a life term prohibition. It doesn't have any specific time period. I repeat the illustration again. 1st May is the last date for the payment. 6 months from there on is expired. Call money has not been paid. The prohibition shall be there for the life term. The person cannot become a director of the company. He has been convicted of the offence dealing with related party transaction under this act at any time during the preceding last 5 years. We are going to see section 188 of the Companies Act. If a person has been convicted under that section, he cannot become a director of the company for a term of 5 years. If in the last 5 years, if he has convicted for the related party transaction, then he cannot become a director of any company. If 5 years prior to 5 years, if he has committed an offense, then after the expiry of the 5 years, he can become a director. That's what this provision intend to say. If he has not complied with subsection 3 of section 152, that is, he has not been allotted a DIN, he cannot become a director. He has not complied with the provisions of subsection 1 of section 165. A person can become a maximum of number of companies, only he can become a director. The law says 20 companies he can become a director, of which that it should not exceed 10 public companies. If that person has become a director in more than such number of companies, he is disqualified to become a director in any other company. This disqualification specified in the clause D, that is the offense involving moral turpitude. Number 2, the disqualification specified in the clause E, that is the call money has not been paid, or relating to the D with respect to the moral turpitude as aspect offense, or any other offense which has been prohibited by the court or the tribunal, or by the offense relating to the related party transaction. If for these 3 offenses, if the person has made an appeal to the court, then in that case the disqualification shall not take effect until the order has been passed under the appeal. That's what the note which is given there says that. We'll go further. We have another provision for the disqualification separately. This is a provision which has been added as a corporate governance provision. A person who is or has been a director of a company which has not filed the financial statements or annual returns for any continuous period of 3 financial years, has not filed the financial statements or annual returns for a continuous period of 3 financial years, or has failed to repay the deposits accepted by it or interest thereon, or redeem any debentures due or the interest thereon, or dividend, or for 1 year or more after the defaulting date, 1 year they have failed to pay this amount. I will call this section as a 3D section: deposit, debenture, and their interest and dividend default. So deposit, debenture, dividend, default. If there is a default for 3 consecutive years with respect to the financial statements or annual returns, that's the first clause. The second clause is 3D default continuing for 1 year or more. That person shall not be eligible to be reappointed as a director in the same company, cannot be appointed in any other company for a period of 5 years from the date on which he fails to do so. This provision is not only applicable for a public company, this provision is also applicable for the private companies also. There is no discrimination in 164. Certain provisions are applicable to public companies, certain provisions are applicable to private company. There is no such discrimination. Entire section of 164 is applicable to both public company as well as to the private companies. If I will call the section 164 as an ineligibility of the person to become a director. If you see at subsection 2, there also it uses the word a person. If you go back, I'm just scrolling up now, there also in subsection 1 it uses the term a person. A person shall not be eligible for appointment as a director. So 164 should be called as a ineligibility section for a person to become a director. Are you clear with this? I have given you another provision here. A private company may by its articles provide for any disqualification for appointment as a director in addition to those specified above. Now here comes a point. A private company may by its articles provide for any disqualification expressio unius est exclusio altarius. Private company can do means public company cannot do. That's what the intention of the provision. Private company can provide an additional disqualification conditions, but a public company cannot do so. The private company should also state the additional disqualification provisions through its articles of association. Vacation of office of director, the next provision. A director vacates his office automatically on happening of the event specified in this section. If you see the subsection 1 starting with the wordings, the office of the director shall become vacant. The shall become vacant clarifies that it is automatic in nature. The board of the company or shareholder of the company or central government, no one can waive or condone the offense by the director and say that the director, you can continue the office. That cannot be said so. It is automatic in nature. Please understand, vacation is post appointment, getting out of the office. Disqualification at the time of the coming into the office. As I told you, that is an ineligibility provision. Here it is vacating provision. Vacation provision 1A has been clubbed to the first provision. If a person has incurred any of the disqualifications specified in the 164(1), he shall vacate the office in all the companies. Suppose a person is here, Mr. X is a director in A, B, C, D limiteds, 4 companies. He commits a default in A company by non-payment of the call money. He will vacate the office from A, B, C, D. Suppose, pursuant to 164(2), if he is not filing the annual returns for 3 consecutive years in A, but he has filed in BCD, he will vacate the office in BCD but not in A. Friends, please understand this. I am again explaining you the second illustration. Mr. X is a director of A, B, C, D Limited. He has filed the annual returns of BCD but has not filed the annual returns of the A. He will vacate the office from B, C and D but not from the A. He will continue to hold the office in the A. The intention behind the provision is, if he is failing to file the returns in A, who else will file if he is vacating the office? So the law obliges him, he should file the returns or he should file the financial statements in A for the company which he is defaulting. Okay, sir, I am understanding that he is responsible for filing in A, so he should not be vacating from the office of A. Sir, why he is vacating from BCD? Tomorrow he should not fail to file in BCD, so remove this office from those companies. That is the intention of the law. Please understand at this juncture, this is not a punitive provision, it is a preventive provision. I am not punishing him from BCD. What I am trying to do is, I am trying to safeguard BCD. This man will not file for these companies also in future. So let's stop him from doing so. So I am asking him to vacate from BCD. Clause B. He absents himself from all the meetings of the board of directors held during a period of 12 months with or without seeking the leave of the absence of the board. He absents himself from all the meeting of the board of directors in the last 12 months. Whether he has got the absence from the board, leave of absence from the board or not, that doesn't matter. He acts in contravention of the provision of section 184. 184 is an interested director provision. If he is failing to disclose his interest or he is not complying with the section 184, clause C and D talks about the same point, that he shall be vacating the office. He becomes disqualified by an order of the court or the tribunal. The court or the tribunal asks the person to vacate the office, then the person shall be vacating the office. He is convicted by a court of any offence which involves the moral turpitude or otherwise in respect thereof to imprisonment for not less than 6 months. However, the office shall not be vacated by the director if he has went on for an appeal. Friends, in the point F, please ignore the word not. It has been amended that even if he goes for the appeal, his office will vacate. Disqualification will not take effect. Vacation will take effect. Disqualification will not take effect. Vacation will take effect. The company in which I have already become a director, I shall vacate the office. The company in which I am going to become a director will not have an effect. He is removed in pursuance of the provisions of this Act. Section 169 of the Companies Act talks about removal of a director. If a person has been removed pursuant to the provision of the removal given under section 169, he cannot continue as a director. A director is holding office because of holding some other office. By virtue of holding an office, he is holding another office. Ex officio. He is a technical engineer, so he is also a director. Then in that case, he cannot hold the office as a director if he vacates from the technical engineering office. That is what the clause H talks about. Liability for the non-vacation. Sir, even after the vacation, if a director is continuing his office, then he shall be liable for those punishment which is given under that section. Suppose if all the director vacates from the office because of any of the foregoing disqualification given above, in that case, promoter of the company can fill the office by appointing certain persons as directors. In the absence of the promoters, central government can fill the office. Thank you, friends. We'll finish up till now. We'll start with kinds of directors in tomorrow's lecture. Thank you, friends.